make an offer. If you'd like, you can step outside, and I'll hear from Mr. Kessler, and then as soon as he's done, I'll have my bailiff go get you, and you can be present for the balance of the sentencing. The choice is yours, and if you want to stay now, but if it gets a little rough and you want to leave, you won't disturb anything, you won't disturb me or the process. Feel free to get up and leave. And again, my bailiff will come out and get you. The choice is yours. Mr. Kessler.
Thank you. May I use the podium?
Absolutely.
Thank you, Your Honor, and thank you for those comments. I really appreciate that. It's been a pleasure trying both of these cases in your courtroom. I don't have a lot to say. I have some observations, and maybe the court can find room to consider them in deciding whether to impose a natural versus a so-called regular life sentence. Because of the date of the crime and the nature of the jury's verdict and the count that we received on the homicide conviction, the court does have the legal option to impose a life sentence. I think I would have a tough time disagreeing with Ms. Miller that it has to be, or to suggest that it would be other than consecutive to the Maribel Gonzalez case. I think it has to be. But first, let me tell you this. I've been doing this for, and I want the Celis family to be aware of this as well. I've been practicing for 41 years exclusively in criminal law, and I have pretty much limited my practice to death penalty cases since maybe 1990. And during that time, I have represented more than 30 individuals charged with first-degree murder, where the government has elected to seek the death penalty. And that was the case here, and that's why I was asked to take the case. And then was asked to continue after the death penalty was withdrawn. I cannot think of a sadder, more depressing case than this. What happened to Isabel. And I'm sure I'm speaking for the entire defense team. This was hard for us. We worked 6 years on this case. And every time we got together, which was very frequently, somebody always mentions this is the worst that they had seen. But that's part of the problem, I think, for Mr. Clements in this case. There was an email provided, I believe, to Ms. Miller, who then provided it to the court and to the defense, that actually came from a juror in this case. It was not a bad email. It was rather kind. But what I found interesting was exactly what Mr. DiRoberto and I were concerned about. The juror mentioned that when he or she saw the bones of Isabel, that they became angry. And the way I read that email, and knowing what they were seeing for the first time, because I at one point saw it for the first time in this case, my concern was that there was going to be a verdict based on emotion, and that it didn't matter who was sitting over there for the defense. Mr. Clements' goose was cooked at that point. We had a lot of litigation over the years about venue, and to this day I feel strongly, and this is, you know, an argument to be made at a different level, but I felt strongly that it just, because of human nature, it was unlikely that Mr. Clements was going to have 12 unbiased jurors. Just when Mr. Di Roberto and I finished our presentation of the case, we talked about it. What would be right? What would be wrong? We felt that we had done our job, and not only established reasonable doubt, but maybe gone beyond that and actually proven at some burden that Mr. Clements was not the one who was responsible for this. But when the jury verdict came back, it was nothing other than I expected. He was guilty. I didn't expect a different result. I didn't expect a different result when I was engaged in voir dire at the beginning of the trial. It just didn't feel like it mattered what we did. It's a very unique case. It was also a very circumstantial case. And as I argued to the jury in my closing, in order for the state to stitch together all the circumstances that it really needed to show that circumstantially, beyond a reasonable doubt, Mr. Clements is responsible for this crime, there were so many real iffy layers to that. So many areas where they could have happened so many different ways. And because of the circumstantial nature of the case, if any one of those layers was not proven beyond a reasonable doubt, I didn't see how it could go any further. But it did, and I wasn't surprised. But for purposes of sentencing, I think the court should consider that. Sometimes it's referred to as reasonable or residual doubt. I think it's present here. Additionally, Mr. Clements is serving 2 lengthy sentences in Maricopa County and is already serving a natural life sentence with a consecutive kidnapping sentence on the Maribel Gonzalez case. There's case law that suggests that facing that kind of a series of sentencings might be considered a reason to show some mercy at this point and just sentence him to life. We certainly don't believe that the court can sentence him based on the felony murder rule and 13116, that the court has the legal authority to sentence him to consecutive sentences within these 3 counts. Because if you take away what needed to be proved in order to prove up the homicide, we're left with nothing else. The state had to prove a kidnapping. They had to prove a burglary. That was the theory of their case. And in order to be able to prove up the homicide. And under 13116, I think that precludes the court from running any of these 3 sentences consecutively. And I may have missed something from Ms. Miller, but I didn't hear the state ask for consecutive sentences.
You did.
Among these 3?
Am I right, Ms. Miller? Oh, okay.
No, Judge, I agree with Mr. Kessler. They do have to be concurrent within.
Because I was going to give you an opportunity to address it. Okay.
Yeah. And so I'm so sorry for the Celis family and the ripple effects through the Celis family. I wish that there was something I could do about that, but there isn't. But it's that emotion that I fear is what doomed Mr. Clements, regardless of what the evidence was. And I think if the court takes an objective view of the evidence and the fact that this was necessary layers of circumstantial evidence, none of which I think reasonable minds could say was proof beyond a reasonable doubt of each level, each layer. There is sufficient doubt here to show leniency and sentence Mr. Clements to natural life, or not natural life, to life. I'm sorry.
Thank you. Mr. Clements, is there anything you wish to say?
There is.
Go ahead.
I find it disturbingly ironic that at the nascence of each of the last 3 trials in which I've been a defendant in this court, Mr. Martyr, you have, in baronial locution, lectured the jury about the importance of a fair trial being afforded to every citizen of this country. You stress to the jurors that if these rights so enshrined in our Constitution were not adhered to, quote, we are lost, unquote. Using Joseph Stalin's show Trials of the Soviet Era, you attempted to illustrate trials of the United States' nomenclature as being diametric to the iniquitous nature of those conducted at the behest of the late Russian dictator. Mr. Martyr, I'm unsure if you were simply repeating some platitude you gleaned from law school or the History Channel in an effort to embellish the verisimilitude of your court, or if you were offering a tacit acknowledgement that the proceedings thereto overseen by your predecessor, and from that point to jury deliberation overseen by yourself, would be anything but fair. Either way, all 3 trials that I've endured in your court would have no doubt made any Soviet chairman of the Council of People's Commissars proud. It's inconceivable how any person with even a semblance of pragmatism or objectivity could call what just happened a fair trial. Mr. Martyr, maybe you believe, like countless others, that a trial is fair so long as it takes place in the United States. Or maybe, also like countless others, you don't practice what you preach and instead embrace the ever-growing ideology that the end justifies the means and all else in between is nothing but ceremony. With alacrity, you saw that these trials took place even though the case was saturated with substantive rulings left by a judge, your predecessor, who was found to be biased by the Judicial Conduct Commission. You denied even look at these rulings unless, of course, doing so would benefit the prosecution. You denied a change of venue even in light of the fact that this city's collective media had chose to supplant calumny for veracity and propagate guilt into the community's minds long before these trials ever even commenced. And it was you, Mr. Marner, specious champion of the American citizen's right to a fair trial, that actually had the temerity to commiserate with jurors after a hung jury and inform them of my record and previous conviction begotten in your court. You assured those jurors that I would not be
the southwest border. This is a natural choke point within the smuggling networks that occur.
to the media, and the media, our so-called fourth estate, didn't hesitate to put what you said to those jurors into print and television as cannon fodder for the next jury. Your actions helped ensure that a guilty verdict in the next trial was all but certain. The trials and the hearings leading up to them are the best examples of confirmation bias I've ever seen. And I've read a lot of books about village hangings carried out by the crown in the Middle Ages, Hitler's fascist government, Pol Pot and his ruthless Khmer Rouge regime, and yes, Joseph Stalin's purges and show trials. I still maintain my innocence, even if such innocence has never been presumed by anyone in this court or the community in which it operates, other than my attorneys and maybe a few people too afraid to utter such an outre belief. Though this experience has tested my trust in the American justice system, I still believe in this system constructed by our founding fathers. It's not perfect, and those good men knew as much. They knew that injustices and unfairness of courts like King George's and in countries like Spain and France could insidiously make their way onto American soil. It's one of the reasons why we have appeals, Mr. Marner, because of judges like you. Maybe in your next perennial discourse to a jury about what isn't a fair trial, you should contemplate using the trials I endured in you and your predecessors' courtrooms as an exemplar instead of Stalin's slightly fair kangaroo hearings. In closing, I'll quote your words, Mr. Marner, words that eerily mirror those of a German journalist who watched in dismay as men in brown shirts lurked toward the newspaper she worked at in Berlin circa 1934. Quote, "We are lost," unquote.
Okay. Jeff, will you give Mr. and Mrs. Celis? Mr. Kessler, anything further from the defense?
No, Your Honor. Thank you.
Okay, I will note the presence of Mr. and Mrs. Celis. Welcome back, folks. All right. Thanks, everybody, for your input. I was thinking about what I was going to say today, believe it or not. And sometimes when I watch these shows and these true crime shows, they'll show the judge giving some speech, and I always thought, not his place, not her place, and it's not my place. My job here is to apply the law, and that's what I'm going to do, without further comment. All right, I find the defendant guilty of count 1, first-degree murder, a class 1 felony in violation of ARS 13-1105, committed on or about April 21 of 2012. I find the defendant guilty of count 2, kidnapping a minor under 15, a dangerous crime against children, a class 2 felony, non-dangerous, non-repetitive, in violation of ARS section 13-1304, and 13-705, 13-3821, committed on or about April 21 of 2012. The defendant guilty of count 3, burglary in the second degree, a class 3 felony, non-dangerous, non-repetitive, in violation of ARS section 13-1507, committed on or about the 21st day of April 2012. The court enters a judgment of guilty, same. The court has weighed the information available to it, and Ms. Miller, while I understand your position regarding comments made that weren't presented to the jury but were made during the interview with the FBI agents, I'm not going to consider them for purposes of sentencing. I'm limiting my considerations strictly to the evidence that was admitted to trial and heard by the jury. That being the case, I think everything pales in light of victim impact. Again, not my place to go on, but I think Mr. and Mrs. Celis did a fine job. The record's been made. I do find that, as to count one, I do find a natural life is warranted. I'm going to order that Mr. Clements, you're sentenced to natural life in prison without the possibility of commutation, parole, release, or any other relief. As to count two, kidnapping, a minor under 15, a dangerous crime against children, I'm going to order the presumptive term of 17 years be served. And as to count three, burglary in the second degree, I'm going to order the presumptive term of 3.5 years to be served concurrently with the natural life sentence for count one. These sentences shall run consecutively to the natural life sentence and other sentence imposed on counts 4 and 5 in this matter. They shall run consecutively to the sentences imposed in Maricopa County under cause numbers CR 2017-005669, CR 2018-000917. Fines and fees, I will order the $500 forensic assessment, $2 victims' rights enforcement assessment, $9 victims' rights assessment. Counsel, oh yeah, that's right, $500 forensic assessment, $250 sex offender registration fee assessment, $50 address confidentiality program assessment. All other fines and fees are waived. Stating clarification, the court's ruling.
Not if you're willing, Judge.
No, Your Honor, thank you.
Very well. Mr. Clements, you can challenge what I did by filing a notice of appeal. It must be filed within 20 days of today's date. Anybody need to make any further record on anything?
I do, Judge. I would ask...
Oh, restitution? I forgot about restitution.
I don't think that anyone is asking for restitution in this case. So if you want to leave it open, Judge.
I'm going to leave restitution open for a period of 1 year from today's date.
Thank you, Your Honor. During Mr. Kessler's comments, he referenced a email that I had received from a juror. I don't agree with the comments he made. I think it was exactly to the contrary, so I'm going to ask that that be made part of the record, even if the court wants to put it under seal.
Oh, very well. And it was, actually, I'm glad you brought that up. I hadn't already filed that under seal.
I don't know, Judge. I know that there were a series of things, but just for purposes of the record, I want to make sure that that email is included.
Yeah. I was thinking the exact same thing when Mr. Kessler was making that comment. What I will do is, I think my J is in here somewhere. Do we have a copy of that email?
Yes, sir.
Okay. So what I will do is I will file that email under seal. Any objection, Mr. Kessler, Mr. David?
No, Your Honor.
Yeah, and I will file it under seal and have it be part of the record, and it can be subject to appellate review.
Thank you, Judge.
Hey, that's a good thought. Thank you. Anything else?
No, Your Honor.
Anything else?
Nothing further.
As I said earlier, and this is for the lawyers, it's a pleasure working with professionals. So thank you for your camaraderie and your assistance, and I'm proud of you, both sides.
Thank you.
Okay, and unless we have anything else, we're adjourned. Thank you all.